Hello class and welcome to another virtual lesson. Today we will tackle the fundamental human right to privacy and the violation of said right, termed invasion of privacy. Once again, I apologize in advance for any audio disturbances on this video and for not being with you on screen. Okay, let's start. So what do we mean by privacy in the term the right to privacy? So according to Thomas Cooley, privacy is simply the right to be left alone. Privacy means, therefore, that being let alone in our personal space, mindset, and our personal devices. And another definition of privacy is the right of an individual to determine what, how much, and when information about himself shall be disclosed. So in other words, privacy also means our right to personal secrecy and confidentiality, and our personal decisions on what to reveal and what not to reveal to the public. So the question now is, how is privacy protected in the Philippines, so in our country? So it is both protected by natural law and the Philippine Constitution. So what do we mean by natural law? According to this sentence, having spurred from natural law, which is immutable and recognized as intuitive, privacy then by no means should be abolished completely. So this means that privacy is rooted from natural law, a law which is given to us the instant we are born. So it is intuitive, meaning it is innate within every person. Therefore, privacy is a right we gain as humans. Hence, it is a fundamental right and should not be completely abolished. Though some people may lose a degree of their privacy because of certain unique status, but privacy itself should not be entirely abolished from anyone. Okay, so there are two core constitutional provisions in the 1987 Philippine Constitution that specifically protects privacy under the Bill of Rights, so Article 3. The first one being Article 3, Section 2, Bill of Rights, 1987 Philippine Constitution. Let me read. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures of whatever nature and for any purpose shall be inviolable, and no search warrant or warrant of arrest shall issue except upon probable cause to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the persons or things to be seized. So it's very broad pano, but we will deal with those concepts one by one later. Okay. Another constitutional provision is Article 3, Section 3 of the Bill of Rights of 1987 Philippine Constitution, which is a continuation of the previous section or Section 2 of the same article. So this provision states that the privacy of communication and correspondence shall be inviolable except upon lawful order of the court or when public safety or order requires otherwise as prescribed by law. Any evidence obtained in violation of this or the preceding section shall be inadmissible for any purpose in any proceeding. So we will deal with these concepts later. So please take note of these two core constitutional provisions on the right to privacy. Okay. Now that we are aware of the core provisions and its contents, let us dig deeper into how different people and entities have varying access and limitations to the right to privacy. First is on privacy of communication and correspondence. So this basically puts a limit to the protection afforded by the Constitution to privacy of communication and correspondence. And that is when there is an existence of a lawful order of the court, or when public safety or public order requires as prescribed by law. If a court, specifically the highest tribunal or the Supreme Court, decides a lawful need to access private communication and correspondence with the oath of the complainant and the likes, as stated on Article 3, Section 2 rather, this serves as legal intrusion or invasion of privacy. The most common law that is directly related to the act of invasion of privacy is the Anti-Wiretapping Law, or RA 4200 or 4200. I'm pretty sure that you have heard this law already. So essentially, this law declares that any use of technological devices to pry or eavesdrop on private communication is unlawful. This is especially when the parties who are being recorded are not aware that they are on tape. So therefore, there is no consent whatsoever. But in the presence of a peace officer, this could be a police or any person assigned for the specific task, they can have the right to access any recorded material when they have a written order from the court, or there is a presence of a written order from the court. So take note that any information gathered or resulting from a wiretapping is not admissible as evidence to any court. So bisan pag na ay big deal or very revealing na nagiingon dito sa wiretap recording, dili gihapon siya i-credit sa court as evidence because the act of getting the information or through wiretapping is an invasion of someone's privacy, which is a fundamental right protected by natural law and the Philippine Constitution. Okay, so take note of that. So as some of you may or may have remembered, one of the country's most talked about alleged wiretapping case is the Hello Garci tapes. So I don't know if ma-recall pa ninyo, but until today, there is still no resolution to the issue. But what conspired were the spread of a said few recordings or clips of recordings with a woman and a man's voice talking about the percentage of votes in the election. These voices were allegedly the current president back then, President Gloria Macapagal Arroyo, and the recording and the COMELEC commissioner, Virgilio Garciliano, is the man's voice. So one famous line deciphered from the recording from the woman's voice is, "Hello? Hello, Garci? Lamang pa rin ba ako ng higit 1,000,000? Or something along that line. So Arroyo's coalition back then were able to bar further investigations through a national televised address to the Filipinos by PGMA, stating that she was the one on the tapes and her famous line, "I'm sorry." And another factor that led to this case not having any resolution is because of the alleged wiretapped conversation of the president and the commissioner. Okay? Though, if you think lang as communication students, di ba? They are talking about something of public concern. Therefore, the information stated on the privileged communication or the wiretap conversation is valid, is of public concern because it is part of an election. But somehow through the power of Arroyo or any other movements, there is still no resolution to the said case. Okay, so that is basically anti-wiretapping law and its example. Okay, moving on. Another is on Bill of Rights and private individuals. So, the Bill of Rights is not meant to be invoked against acts of private individuals. Meaning na ang Bill of Rights are mga sections or provisions sa Bill of Rights that protects privacy should only be used as a defense against the state and not on the acts of private individuals or establishments. So the best example here is the case of People versus Marty. So in the case, Marty delivered 4 gift wrap packages to Manila Packing and Export Forwarders, or MPEF, to be sent to Zurich, Switzerland. So before delivering to the Bureau of Posts, Manila Packing and Export Forwarders, as protocol, the package was opened for final inspection and was found to contain dried marijuana leaves inside. Consequently, Marty was convicted for violation of the Dangerous Drugs Act, or RA number 6425. So Marty appealed to the court that the evidence should not be admitted by virtue of the privacy clause afforded by the Constitution. But the court held the search was made at the initiative of the proprietor of a private establishment, which is the Manila Packing and Export Forwarders, for its own private purposes without the intervention of police authorities. So violations against unreasonable search and seizures may only be invoked against the state. So if a private institution, based on their protocols, has done a deed that may constitute to unreasonable search and seizure, dili nimo magamit ang Bill of Rights against sa ilaha. This is why companies have terms and conditions and privacy disclaimers that everyone should be aware of. So, any unreasonable searches and seizures na pwede magamit ang Bill of Rights should only be done by the state. Kung ang state mismo ang nagbuhat, or the state or the government mismo ang nagbuhat og unreasonable search and seizure, that is when you can use the Bill of Rights, you can invoke the Bill of Rights or appeal the Bill of Rights to the court, okay, as your defense. Okay, I hope that is understandable. So the question now is, when is search and seizure reasonable? Search and seizure. So the need for a search warrant is not to be determined by any fixed formula, but it is to be resolved according to the facts of each case. So a search warrant can only be issued once facts and a case is deposited to the court, and when a search is necessary for the advancement of a case as decided by the court. So this can be done through the oath and affirmation of the complainant and the witness, as well as the specification of what place to search and what things to seize, okay? So these specifications must be stated in the search warrant before a search warrant becomes valid, okay? On the other hand, there must exist a probable cause upon which a warrant of arrest or an arrest is made. So a warrant of arrest and the arrest itself should have probable cause, which can be determined by the law and peace officers. So seizure is basically the arrest of non-living things when an object is taken into the custody of the government or the court for inspection or for evidence, while arrest means to a person, okay? Earlier, we have discussed the constitutional provisions that protect privacy. Now, we also have other laws that protect this right. Starting with the Civil Code. So, in this code, it provides that every person shall respect the dignity, personality, privacy, and peace of mind of his neighbors and other persons. This code also recognizes the privacy of letters and other private communication. So that is self-explanatory at what this code protects and what this code recognizes. Okay, so moving on. Another is on the revised penal code. So in this code, there are acts stated that constitute to intrusion or invasion of privacy. One being the revelation of secrets which have become known to a public officer by reason of his official capacity, whether it be deliberately or accidentally. So this happens when secrets are revealed through the abuse of power or office by an individual of power or office, using intimidation to make informers talk, whether gituyo ni siya or wala. So that constitutes to intrusion or invasion of privacy. Another is the trespass of dwelling, or literally invading the private and personal space of an individual to gather information. Okay? Another is discovery and revelation of secrets through seizing papers and letters and revealing their contents. So, when information are revealed through unreasonable seizure and then publication of said contents in any form, that is also an act of invasion of privacy, according to the revised penal code. Next is the rules of court. The rules of court introduces privileged communication. This concept limits the right to information in favor of privacy. So this is basically the right of a person of duty to not reveal confidential information na nagather nila in the practice of their jobs. So they cannot be compelled to reveal information. For example, an attorney and his co that are handling the case of a client, they cannot reveal information without the consent of the client. So another is ang mga medical personnel or anyone that handles medicines, surgeries, and obstetrics, ang mga medical legal, or any medical procedure for a case without the consent of the client, or the patient rather. Okay? Next is ang isang ministro or pari, kahit na may in-reveal na big secret sa confession or big deal sa confession, he has the duty to keep silent without the consent of the one who confessed. Okay? And finally, a public officer cannot be compelled, whether he is still in office or no longer in office, to reveal in confidential communications if not of public concern, if the topic of the communication is not of public concern. So they cannot be compelled to reveal. Okay? Moving on. Here are special laws on privacy, so other laws that protect certain privacies by certain people. Number one is the Youthful Offenders or PD 603 Child and Youth Welfare Code. This protects the youth offender from any dire effects on his record once the civil or criminal liability is fulfilled or answered. Through this, they are given a clean slate once charges are dropped or any penalty is already satisfied. So all records will be destroyed and the information is considered privileged and should not be revealed to the public. Okay. Next is Rape Victims or RA 8505 or Rape Victim Assistance and Protection Act of 1998. So this is basically the non-disclosure of any facts that may reveal the identities of rape victims. Okay. Next is Family Courts Act of 1997, RA 8369. So any cases against families done in family courts, families and its members should not be revealed to the public unless necessary or when the judge decides it should be revealed. Next is AIDS Patients, RA 8504, Philippine AIDS Prevention and Control Act of 1997. So this ensures the medical confidentiality of AIDS patients, so which protects the identity and status of persons with HIV. Okay, and finally, the E-Commerce Law or RA 8792 or Electronic Commerce Act, which shields the privacy, confidentiality, anonymity of users and provides a guideline for electronic commerce. Okay, now we have come to the controversial aspect of privacy with which is its relationship with public figures. So, do public figures have no right to privacy because they are innately public figures? So, we will answer that question. To answer, let us first define what is public figure. So, according to Professor Prosser and Keaton, a public figure is a person who, by his accomplishments, fame, or mode of living, or by adopting a profession or calling which gives the public a legitimate interest in his doings, his affairs, and his character, has become a public personage. So people who are sources of public interest, people whose actions may affect the public, and people who holds office or electoral elections. So public figure in the aspect of their work or their function in society can become public concern or public interest. Even the things they do or the things they handle become public property, so the people have the right to know. So their privacy is limited, other than people who are solely private people who have no affiliations, accomplishments, fames that sets them apart from other people. Okay, so public figures can be celebrities, officials, elected officials, or even journalists or reporters that you can see on TV, or any person that may or his or her act may affect the public, or the public has concern over. Okay? To further understand the concept of privacy and public figures, we have three landmark cases here. So I'll be stating them to you through my voice, so please listen. The first one is Borjal versus Court of Appeals. The court explained that through this case, that even if a person is not a public official or at least a public figure, as long as he is involved with a public issue, he could be a subject of public comment. So, even though you are a private person with no affiliations or accomplishments at all that sets you apart from other people, like being an official or a celebrity, even though you are a private person, if you are involved in a public issue, you can be interrogated or you can be asked for questions and you can provide answer, and also you are open to become um, witnesses, okay, or your comments or your words have effect on the case even though you are a private person, so you can be called upon to the court. Okay, so this concept in this case widens the scope of public figure, because a private person can be involved in a public issue and is therefore constitute to public concern or public interest. Okay, next is on Ayer Productions Party versus Capulong. So, Judge Capulong of the Makati Regional Trial Court issued a writ of preliminary injunction against Ayer Productions, producer of the Four-Day Revolution, on the 1986 People Power Revolution, to cease and desist from filming and producing the miniseries after Juan Ponce Enrile filed a complaint alleging the production was a violation of his right to privacy. It was held that the film did not constitute an unlawful intrusion to Enrile's right to privacy, since Enrile was a public figure at that time. Enrile's, furthermore, it held that the extent of the intrusion is reasonably necessary to keep the film a truthful historical account. So, the Four-Day Revolution, or the miniseries revealing the 1986 Philippine or the People Power Revolution, is an attempt or aims to create a accurate and authentic historical account of the said event. So, the need to cover some intrusion of the privacy of Enrile must be done so that the the film is truthful to the historical event. So the appeal of Enrile that the film was invading his privacy was barred by the court because Enrile is a public figure. He is an official then and at that time, and also because there is a need to cover those aspects of Juan Enriquez's life and personality as a public figure to create a truthful account of the people power of 1986. Okay, so I hope that is understood. Next is on Lagunsad versus Soto de Gonzales. So the Philippine Supreme Court applied this test to solve the conflict between the right of the family of the deceased Moises Padilla to have their privacy protected and the right of the writer to write about a public figure like Padilla. So the writer is aiming to create a fictional story of the deceased Padilla involving his or her family. So it is a form of novella. So there is already an agreement to license the said story, but then the family appealed that the right to their right to privacy under the court. So the court held that um, the public being a public figure does not automatically destroy in total a person's right to privacy. So no matter how public a figure he or she may be, the right to invade a person's privacy to disseminate public information does not extend to fictional or novelized representation of a person. So in this case, the the privacy of the bereaved family of the deceased Moises Padilla was given the 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 ruling of the court, and the license publication was then abolished, and the family was given just compensation to the damages created. Okay, moving on. So basically, what the Lagunsad case was stating that even though the public person, there is still an extent to their right to privacy wherein the press or anyone should not have access to. So in the case of Moises Padilla, who is already deceased, the family wanted to protect the image of the deceased, and of course the family, the image of the family. So the court stated that no matter how public a figure may be, they still have um, the right to privacy. Okay. Now let us venture to the four most common invasions of privacy or acts of invasion of privacy according to Professor Donald Gilmore. So these are common practices of the media or by the media that constitute to invasion of privacy, namely public disclosure of private and embarrassing facts, intrusion, portrayal in false light, and appropriation for commercial purposes. So let us tackle these one by one. First is on public disclosure of private and embarrassing facts. So you need to ask yourself when gathering facts, is this information, is this private? Is this intimate? And would this be offensive to the image or thinking of a reasonable person? So if the answer is yes to everything, then don't disclose the fact. So for example, if you were to write about how a person still wets the bed at the age of 25 when he sleeps, so that is private and the information is embarrassing and does not affect the function of the individual in society. So remember that truth is not a defense. You need to be mindful and critical in the facts you share or publish. Next is on intrusion. This is basically going too far in gathering news, so such as invading private property or private gatherings, the former being trespassing and the latter being gate crashing. So the safest way to go about this is that you make sure of the distinctions between public places and private spaces. So another is the use of secret surveillance or bugging someone to eavesdrop on their conversation. So this does not include public surveillance cameras installed by private establishments or by the government. Uh, these comments are the CCTVs or the closed circuit televisions. So CCTVs are meant to keep the public and the property safe. So CCTVs are not there to invade a person's privacy, but to protect the public by deterring criminal activity and by providing material evidence when a crime or accident has been caught on film. So access and permission on these tapes are given to the establishments or the property's owner. So with their consent, any peace officer can access their footages and use them as evidence in court in the presence of a search warrant. Next major invasion of privacy act is the portrayal in false light. So the unflattering, highly offensive portrayal in words or pictures of a person as something he or she is not. Careless use of photos or inaccurate attribution of a publication. So pasabot ani kay gamiton ang imuhang words or pictures of you taken of you on another context, like when you are merely an audience of a rally, but then a picture of you was used to portray said rally on newspaper as if you are part of it. So this happened also very recently to a famous vlogger or TikToker, Liza. Sorry if I am wrong in her name, but basically she teaches English through her platforms. But one of her videos or a screenshot of her videos was used in a television report stating that stating the lapses or reporting the lapses of DepEd in the new normal education system. So that is a portrayal of her in false light, which is an act of invasion of her privacy and the practice of her profession. Okay? Lastly is the appropriation for commercial purposes, or the unauthorized use of a person's name, photograph, likeness, voice, or endorsement to promote the sale of a commercial product or service. So for example, you visited a pizza place and you took a photo. Then the photo was used by the establishment to advertise their pizza and put words that you have not said to promote how delicious their product is. All this done without your consent. Uh, Therefore, this is an invasion of your privacy. You can sue the establishment for charges or have their advertisement taken down and compensate you for damages. Okay? Excuse me. So the two factors you always have to consider when reporting about private information is newsworthiness and consent. So you always have to weigh your facts based on these two weight scales, the newsworthiness on the left side and consent on the right side. So newsworthiness, so you ask yourself, will the public benefit from this information? Will this not be offensive? Is the subject matter objective? Is this information public concern? So therefore it is newsworthy. And of course consent. So if a private information is sought after, so if it is private, if it is confidential, if it is sensitive information, is about to be published or you are about to publish it, you should have the consent of the parties involved. Okay? Those are the two factors that you should consider when handling news involving privacy. Okay? And that's it for our lesson on the right to privacy. You can comment down below if you have any questions, and please answer the activity sheet provided to you. Then I will see you on our next lesson. Thank you for listening. God bless and keep safe always.